as other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files would now be before the bench formally so. Right?
Yes, my Lord, I believe now I can be able to make the clarifications. We are starting with the other immediate background that we need to make these clarifications and we take...
No, Mr. Let us finish with quorum first. There's a quorum there's a quorum in E013, which was consolidated in Kergoya with E014. Let's take quorum on that file.
There's something wrong. Your Lordship is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not had it perhaps would be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
Why are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My Lord, I'm well guided, but when Justice Rima was giving the clarifications, I never heard him clarify whether the Kergoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kergoya. Because of course, if there is no integration, Your Lordship, then there is a run that is made.
My Lord, may I say something?
Let me answer him. You said the record speak for himself. And for record, matters which came from Kergoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kergoya was already consolidated. Those proceedings which took place in Kergoya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11th by Judge Richard Mwongo, these were the directions. The petitions, the petitioner in E014 2024 to serve their amended petition on all parties. Similarly, the petitioner in E013 2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Kergoya under the Kergoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Karibaya. So this court has not consolidated any matter. Petition number E14, E014, and petition number E013 are hereby consolidated. The parties who appeared before the Karibaya court were given those orders. Those were your orders.
And with your permission, presiding judge, the reason why Nairobi has not opened another file to put together all the files from Karibaya is this. Going by the orders which were issued by Karibaya court, there was a specific order that because of the transmission, parties will still file their documents under the Karibaya CTS, that is the contracting system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place. Thanks.
I presume we will now raise the issues that one raised, particularly arising from the issues in Karibaya. And
we will then proceed and take quorum on it. They were consolidated, so we will not take further quorum on this one.
I had issues with the water. Did you raise something?
Section 7 of the
You can read yes. It doesn't override the right to represent.
I'm repeating.
Can she then say her piece? I say mine.
Which matter we now get?
Hey there. Need a trusted dealer in fencing?
We have 0115.
We have several
We have 0115.
My lord, I wanted to say that
Yes.
the only matters before this court are the matters which had ex parte orders. The matters that came from Karibaya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders. We have E15
E15 has
conservatory orders, but E13 and E14, although from Karibaya, they were filed before impeachment and they had no conservatory orders.
I hope again we have I'm reading the number of applicants in this matter from the is yes. My lord, the clarification that I seek to raise emanates against this general background. The first one is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regards to that sitting, my client wrote a letter to the Honorable Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of under the 2010 Constitution, under the 2010 Code. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, your lordships, that you are convened by the Honorable Lady Justice Willie, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, And we do this every day. I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may I?
I think I have a right to raise those issues.
Professor Mugai, just give the fellow Mugai time to.
I just wanted for good order,
Okay,
my Lord,
is
if
that
I may.
clarification, Mungai?
I am Mungai. I believe he will speak in response as soon as
Proceed.
Then
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Mugai was a former Attorney General. I respect him. He was also my teacher, like Professor of the criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's before the court. I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Mulima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. But under the 2010 Constitution, the constitutions provide for the Bill of Rights. My Lord, under the former Constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on Saturday. And my Lord, we are also sitting here pursuant to an order made by the Honorable Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal application. Issue number 2. Arising from that.
You apply that we discharge the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My Lord, number two, and it is implied in the applications for disqualifications that we have filed. Number two is that we raise the issue that for purposes of the Saturday city and today's city, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that we have made. But Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, three issues worry us. Number one, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number two, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue is speak for the Wananchi and with a clear conscience. Two things. Well, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number two, my Lord, is this, the issue of bias. And this is bias by the order of the
I think, Mr. Mungai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you better.
Maybe there is another issue that
yes.
does not have to do with those prayers. But the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about four matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? There are an express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application is clearly not permissible.
Mr.
So that, my Lord,
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is what.
But if you have an issue with that, please don't make a generalized generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
Well, sir, just to add on what my lawyer has submitted on.
Just a minute. With the permission of the presiding, I wish to say this. I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
But allow us to worry when we have grounds to worry. Senior Counsel Mute and Counsel Ndegwa, you know, when you argue the way Mr. Mugai has argued, that court sat on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai, let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We haven't finished. In E015 in the report, the Deputy President is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ngoya will be making submission. But madam, do give us, these are very weighty matters. This E015 in Kiroboya. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday? Because permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the President that will be set for the removal of deputy presidents in future and the removal of presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this court.
There's no other word.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the three files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Justice, it necessitated us to address you, Your Lordships, on 165 clause 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally satisfied as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued upon us today, You repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority? And the files with orders are the only ones that the court is sitting on a Saturday? We are called, in the lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectively.
My Lord, with your kind permission, for the record, Dr. Kamoto for the simplest point in issue 15. I believe the reason we are here and the reason why we took forums is because we recognize that there are different parties in these proceedings. So it would be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the office of the court. So in this regard, my proposal is as follows: that each of the parties whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and so on. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issue, because the federal respondent has a pending application which is being filed, a preliminary objection, which even contests the jurisdiction of the High Court to hear the matters, because it is a matter related to the nomination of a presidential and overheaded president, which in our view lies squarely within the domain of the Supreme Court. So we want a golden opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
For the first interested party, Mr. Lawyer, I was about to interject when when counsel, Mr. not like the other one.
Gachagua?
Yes, whatever was addressing, and that is exactly why I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which application can only come after an application. We are now with my application, Your Lordship.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench.
Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, your Lordships, my lady, were 522, 509, 537, 528, 525, and 546. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerogoya, was equally slated for empanelment before the Chief Justice. To date, your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, your Lordship, that when we appeared before you on the 16th of October, your Lordship, we sought your indulgence, your Lordship, to have a further mention on the 18th of October.
Hearing for Professor Kindiki, listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes, Mr.
My lord, you have been invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be through a substantive application to which all parties must respond. I think my concern then, Ndegwa and
my learned friend Kibe, is that you are taking the court for a long ride and we are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you'd say?
My Lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My Lords, with your papers, of course. My name is Manjur Modi. I am acting in person. We filed an application of the certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 14th of October, 2024. Unfortunately, some of the prayers we were seeking have been overtaken by events. My Lord, and today, as we have heard, our applications have not been placed before you, and we are just concerned that our application will events will once again overtake our application, my lords and my lady. So we're asking your kind indulgence, if you will please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
My lords and my lady, for the 15% party in 15, may I just be heard for 1 minute only. My Lord Jandra asked an important question. How do we move forward? Now the paradox, as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrema about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date.
An adjournment, is that if Mr. Ngoy applying for an adjournment because he's saying, and perhaps rightly or wrongly, that even the recusal application comes after determination of the question of empanelment. If that be so, and they may leave, they normally leave court, they left Senate, may leave court, we let them say whether they're applying for adjournment.
Is that remark, they normally leave court, they left Senate, my palatable in this court, my Lord? I need that.
No, because it's an adjournment.
Is that remark palatable for my Lord and my lady? But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment, because Mr. Ngoya is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my Lord, because I'm entitled to take it.
I have no problem withdrawing. You're my friend, but no, I have no problem, my Lord. I withdraw the remark, but there is practice.
Thank you. Let me now address the question as addressed. My Lord, Professor Jenda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted, because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrema, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through Lanet's colleagues, Kiba Mungai, and Lanet colleague, Mr. Ndegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that regard that my Lord Jan Mrima asked, how do we move forward? I also had my learned mentor, Professor Gidu Mwega, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. They'll have a determination on that question. I humbly plead.
Sorry, Chief, again, there were no conditions for too long. Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. They actually knew of it, or should have, they would have found out. The letter, which was written this morning, which we have, it was written on the 20th of October, as actually one pertinent question disposing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fluxion of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. May we be heard? Yes. My Lord, allow me to assist the court. And, my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, Justice Katz, respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So, my lord, what is the fuss about it? So, my lord, my request is that the application, this speech by the petitioners, is solely meant to delay the business of the day. And, my lord, I request in public interest, my lord, I request in public interest that you give directions. We proceed with the application. We are here to respond. The application for conservatory orders, and my lord, the application for conservatory orders, and my lord, you also hear our application to set aside the conservatory orders. My lord, that will make juridical sense and promote public interest. Thank you.
My lord, if I may just add.
This court has the control of the proceedings. And this is a very weighty matter. It concerns the deputy president of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this action we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.